Okay, so let's break down the three issues that Marshall is addressing in this case before we get to the fun stuff about whether or not the Supreme Court is empowered with judicial review. So, the first thing that Marshall says he needs to tackle in this opinion is, does William Marbury have a right to his commission? And this is a pretty easy question for the court to answer because the commission took effect as soon as the president signed it. But that doesn't do William Marbury any good because he can't utilize it unless he possesses it. And so the question is, does someone in either the Adams administration before they left office or now the Jefferson administration that they're in office, do they owe it to William Marbury to deliver it to him so that he can possess it? Yes. The second issue is, does the law grant William Marbury a remedy? And this is a pretty easy thing to answer, too. Um, what John Marshall says is the very essence of civil liberty certainly consists in the right of every individual to claim the protection of the laws whenever he receives an injury. One of the first duties of government is to afford that protection. In other words, if you get wronged, you go to court. And the government is supposed to provide a way so that that wrong can be righted. So the question is, how do you right this particular wrong? And remember, issue 3 said, is the remedy a writ of mandamus to issue from the Supreme Court on original jurisdiction? And what we really should do is break down that statement into its component parts. Let's deal with first, is the correct remedy a writ of mandamus? I promised you an explanation of this. So, a writ of mandamus is just a fancy Latin phrase for a legal order to get someone to do something. It is the opposite of a legal writ that some of you might be more familiar with, and that is, what kind of writ do we have when we order someone to stop doing something? And that's a writ of injunction. So a writ of mandamus is sort of less well known, but yeah, this is absolutely what Marbury should be doing because if James Madison, the new Secretary of State, should have given him his commission, a judge should be able to write a legal order through a writ of mandamus to Madison saying, please deliver his commission. There was an interesting little side note in the opinion about whether or not a cabinet secretary really has discretion over whether or not to deliver a commission. Um, and there are times where members of the executive branch, not just the president, but also cabinet secretaries, have the power to decide to do something or not to do something if they want. Because they're the experts on foreign policy. They are the experts on fighting war. They are the experts on collecting taxes. And sometimes they have the ability to choose sort of tactics or make certain choices about how to do things. And in a lot of instances, the only way that you can sort of criticize the abuse of that discretion, that the way you utilize that decision making power, you couldn't go to court. You could only answer for, I'm so sorry, you could only answer for those problems by getting in trouble with the president or getting in trouble with the voters and getting voted out. That's what Marshall means by those actions are only politically examinable, not legally examinable. But this isn't one of those instances where a cabinet secretary does have the choice, does have the discretion, because this is an instance where there is a duty assigned by the law that part of the Judiciary Act that allowed these judgeships to be created. One of the things it said was the commission has to be delivered to someone after they've been confirmed to office. And so the cabinet secretary has a duty assigned by the law, and an individual's rights, in this case William Marbury, depends on the performance of that duty. It seems clear that the person, in this case Marbury, has the right to resort to the laws of his country for a remedy. And we'll get into this. You don't really need to know what this is until the tail end of class when we get into this issue. But the notion that there are certain things that the government can do that the Supreme Court can't review is what we call political questions doctrine today. And again, this was the very first time that something like this had ever been litigated before the Supreme Court. So here's the final part of this broken down step-by-step approach to issue 3. So uh, is the writ of mandamus the correct remedy? Yes. Can a writ of mandamus be issued to a cabinet secretary? In this instance, yes, because the whole process of getting people appointed to the bench includes the law says that the Secretary of State is supposed to deliver the commission, and so therefore, if he fails it, then a writ of mandamus can be issued to force him to do the job that he was supposed to do. Here's the problem. Can the Supreme Court issue a writ of mandamus through its original jurisdiction as conferred by Congress? If the answer is no, it sets up a conflict between what the Constitution allows and what Congress has done. Because who told William Marbury that where you should go to get this writ of mandamus should be the Supreme Court in an instance where a legal case begins and ends at the Supreme Court? It isn't the language of the Constitution itself. The language of the Constitution says the U.S. Supreme Court will have original jurisdiction over a few minor areas of law. None of them include writs of mandamus for cabinet officials. So why did Marbury go to the Supreme Court to seek this writ of mandamus if it's not something that the Constitution says, yes, in these kinds of cases, go to this court as a matter of original jurisdiction? The reason that Marbury took his lawsuit immediately to the Supreme Court was because when Congress was setting up the legal system for these new federal courts, it said the Supreme Court will have original jurisdiction in cases where a writ of mandamus is required. So you have Congress saying that the Supreme Court has original jurisdiction over something that the Constitution says isn't part of the court's original jurisdiction. So it sets up this conflict between Congress tacking on something to the court's list of cases that it can hear and what the Constitution says. So let's go look specifically at what the Constitution says. The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made or which shall be made under their authority, to controversies to which the United States shall be party, to controversies between two or more states, between citizens of different states. All this says is, if your kind of case meets any of these criteria, you have the right to go to some kind of federal court. It doesn't tell you which federal court. Normally, you would assume that you would need to go to the lowest level of federal courts, and if you lose there, you can appeal to the middle level of the federal courts, and if you lose there, you appeal to the Supreme Court. Except, in all cases affecting ambassadors and other public ministers and consuls, and to those in which a state shall be party, the Supreme Court shall have original jurisdiction, the kinds of cases that begin and end with the Supreme Court. In all other cases before mentioned, the Supreme Court shall have appellate jurisdiction. In other words, they can hear all of these cases, but unless they are these cases, the only time the Supreme Court can hear it is on appeal. Now, there can be exceptions to the Supreme Court's appellate jurisdiction. There'll be some kinds of cases that might not ever be eligible to reach the Supreme Court, and Congress is in charge of writing those exceptions. But that's not going to become an issue in this case. One other thing that you might point to in this bullet point and say, doesn't that give the Supreme Court original jurisdiction? Public ministers and consuls does not mean cabinet secretaries. It means foreign government officials, ambassadors, and sort of other embassy staff. So yeah, there's that. You might have thought that's a get out of jail free card for William Marbury. Unfortunately, it is not. What does original jurisdiction look like today before the Supreme Court. It's a minor part of what the court does. Maybe one or two, sometimes zero cases per year. And it's usually when two states are suing each other. And why would states sue each other? Usually because of water rights over like a river border that the two states share. And remember, I said that in Marbury versus Madison, they actually, all five justices sat together as like, and conducted a trial, right? And swore in witnesses and took testimony and that kind of thing. Not anymore. The court today appoints a special master, sort of like a consultant, to handle the trial, and the special master would then like he'll take or he or she will take all the testimony and then write up a long report of what all the facts were, and then submit that report to all nine justices, and they will decide, who wins the case. Okay, so I'm going to pause here again because I want you to read a little bit more in the case, and then we'll get into the arguments about judicial review.